Hi, everyone. Thank you for joining us for our discussion on abortion. I don't typically discuss this particular topic because it is such an emotionally charged topic, and it's very difficult to get people invested in a conversation that looks at this topic from a very critical and legal perspective. And so it's just a very difficult topic to address. And most people, based upon my experience, they are not really interested in looking at the nuances of this particular situation. And so oftentimes people are, very set on the way that they view this issue, and they are not particularly interested in discussing other issues related to the topic. But this topic is extremely complicated. And it would be helpful if people really delved into the complicated nature of this particular topic. And so there are all of these competing interests that are going on with respect to this topic. And we really have sort of a great unknown with respect to abortion. And it looks like increasingly there are Hegelian and Huxleyan types of dynamics associated with the entire abortion dynamic. And so we're going to get into that. And with respect to Hegel, what it looks like is that there is perhaps a legal outcome that is ultimately anticipated, and we are dealing with the steps leading up to this ultimate outcome that has perhaps a very Huxleyan feel to it. If you are not familiar with Huxley, you might want to check out um, there's a movie, a film, there's a book, of course, but you can also just look at the film, and it's Brave New World, and you will see some of the dynamics that we're going to be addressing today. Now, of course, we are in the election season, and we have a couple of days left before election day. We have an unusual election process going on right now, of course, with all of this early voting and all of those dynamics. But one thing that stands out is some confusion that people have apparently about not only the branches of government, but the election processes and what the outcomes will result in. For instance, a lot of people believe that the selection of the president weighs heavily on the abortion dynamic. They believe that the president has some sort of major sway with respect to abortion decision making. And that is simply not the case. Who does have quite a bit of sway, however, is the governor of the various states. And so we're going to touch on that so people can have a better understanding of why the governor is actually more important than the president in terms of abortion dynamics. And so, what I also want to point out is that, and this is something that people forget, it's this dynamic of substituted judgment. Many people believe that they are actually selecting the president of the United States when they vote, and there's a lot of energy surrounding that. It's very unfortunate that many people don't understand that they are not selecting the president. As a matter of fact, the president isn't actually voted on election night. The Electoral College votes on the president, and the Electoral College is the entity that actually selects the president, and this is after the actual election day that we have. And then, of course, all of that is certified at an even later date. And so a lot of people, for many reasons, don't understand that dynamic and really believe that individually their vote is something that's really important and it counts in a way that it doesn't count exactly. And some of you might even recall that there can be instances wherein the popular vote and the electoral college votes, they don't go together, and they may not be consistent. And so people need to understand that, because some people are really worked up about the election process and talking about, what might happen if one group or the other group does not have their candidate as the winner. And so, again, it's just really important for people to really think about the true nature of the election process and all of these dynamics of substituted judgment. We have substituted judgment with respect to the elections. We have substituted judgment with respect to court processes. And so sometimes the jury may go in one direction and that might be circumvented. And so people need to understand that when thinking about the law and these processes, because the public doesn't generally have the power that it believes it has in terms of the political processes and just the system of governance that we have in place. And so we're going to talk a little bit more about that later. But right now we're going to jump into this abortion discussion, because there are so many questions about the abortion debate that are not out there. There are questions, but people are not asking the questions. People are not talking about the questions. And I'm talking about the general public. Now, according to Pew Research, it's not clear how many abortions occur each year. This is because there are different ways of collecting the data, and also there is limited data on the use of what's known as the abortion pill. And so we don't have exact numbers, but the numbers appear to be in the hundreds of thousands. And we're talking about the United States, and so we're not looking at other countries at this point. And so there are a number of legal questions about abortion that go unanswered in terms of the general public. There are questions about maternal rights that we don't really discuss. Sometimes people just get bogged down with the woman's body, the woman's choice, or they get bogged down in the fetal right to exist, and then they don't really take it any further. And then some people get bogged down in moral discussions while ignoring some of the legal dynamics. And so we've got questions about maternal rights. We have questions about fetal rights. There are questions about paternal rights. And interestingly, this has not been discussed really, is states' rights. Yes, states' rights and science rights. Yes, and so this discussion of abortion, this topic, is broader than simply talking about the right of a woman to have an abortion or to not have an abortion or to control her body. So there are a few other things that are going on that are not addressed because, again, many people are having these very simplistic discussions about the topic, and many of the discussions, again, are emotion-focused discussions. What's also interesting is when trying to address the topic of abortion and the most recent court case, most people have not read this particular court case. This includes all of these individuals who had so much to say as soon as the court case came down. Literally within minutes, there were all of these people with all of these opinions, and some of them legal opinions, when they had not read the actual case. And so that also complicates matters because there's something specific about the case, and we need to understand the case before jumping to conclusions about the case. That will allow us to do a cause and effect analysis. But because the case is over 200 pages long, most people were not inclined to read the case. And even many of the people who are advocates on one side or the other, they still have not read the case. They haven't read one page of the case, but they are offering all of these opinions about the case. Now we're going to look at some of the constitutional dynamics related to this particular case and why the case went in the direction that it went. One thing that was spelled out in the case is that the right to an abortion is not actually spelled out in the Constitution. It's not enumerated. And what the court was basically saying was that this isn't really something for federal jurisdiction. This is really something that is reserved to the people and the states. And so, therefore, what they were saying was this needs to go back to the states. This is not something that is a federal constitutional issue. Because again, they were saying that they could not find in the Constitution this right, a constitutional right to an abortion. And then they go to great lengths to explain the rationale behind their decision making. So this wasn't a decision to outlaw abortion. And many people thought that. They thought this was a decision that outlawed abortion. But that's not what was going on. What they were basically saying was that it wasn't even any of their business. They are saying this is not the business of the Supreme Court because this is not a federal constitutional issue. And this really needs to go back to the states, to the people, because it falls under, according to them, that dynamic known as police powers. And police powers are not powers of police officers. It's the police power, that welfare, health and welfare power that rests with the people and with the states. And here we have the holding from the Dobbs case. And if you note, it's 213 pages long. And this case was decided in June of 2022. And the holding is right in front of you. And so it indicates here that the Constitution does not confer a right to abortion. They are not saying that a woman doesn't have a right to an abortion. They are simply saying that the Constitution does not confer this right, and therefore the Roe case, the Casey case, these are overruled because, of course, there was the indication in the cases that there was a constitutional right to an abortion. And all the Supreme Court is saying in this matter is they don't see that right spelled out in the Constitution. They don't even see a suggestion of it, according to them. They also indicate the authority to regulate abortion is returned to the people and their elected representatives. One of the reasons why abortion and the regulation of abortion and the oversight for abortion is returned to the people in the states is because that's the entity that actually oversees the practice of medicine. And so the practice of medicine is a state regulated dynamic. It's not federally regulated. The general practice, the general licensing, what a medical doctor can do and can't do, that's all under state jurisdiction. And so what Dobbs v. Jackson did essentially was remove the jurisdiction from federal jurisdiction to state jurisdiction, or the jurisdiction of the people and the state. Now I want to address something very important in terms of language and how we are viewing what is going on with respect to abortion. What exactly is abortion? Abortion is supposed to be pregnancy termination. Now, pregnancy termination is its own thing. Pregnancy can terminate in delivery, quite frankly, but Pregnancy can also result from an induced or spontaneous abortion. It can terminate in a stillbirth. So there are lots of ways that pregnancy can terminate. And when individuals are talking about abortion and abortion rights, there seems to be some conflation with fetal termination, meaning terminating the life of the fetus. And these are not the same things. And this is a part of that nuance that is missing from many conversations. To terminate a pregnancy is one thing. To terminate a fetus is something different. Now, sometimes those two things occur simultaneously, but they don't have to. There's no requirement that pregnancy termination must also mean a fetal termination. However, that's the way it has often been construed, and that has led to a number of unanswered and unaddressed legal questions. Now, our focus for this discussion is not on you being told what to think. The focus is on bringing up questions about some of the assumptions that we've made and about some of our thoughts about this entire dynamic. A number of questions, again, have gone unaddressed, and hopefully we can start to talk about some of those issues. And so one thing to keep in mind with respect to pregnancy is, again, the definition of pregnancy. So we're talking about pregnancy termination. What are we really talking about? Again, some people think pregnancy termination and abortion are synonymous, or fetal termination. They believe that pregnancy termination and fetal termination, that these are the same things. But when we look at the description, we see that it's not necessarily the same thing. So what is pregnancy? It indicates here, pregnancy is the term used to describe the period in which a fetus develops inside a woman's womb or uterus. The pregnancy period lasts about 40 weeks, or just over 9 months, and measures from the last menstrual period to delivery. And then you can see a breakdown of the various trimesters. Now, when we are talking about the right to an abortion, what we are talking about technically is the right to terminate the pregnancy, the right to stop the fetus developing inside of the woman's womb or uterus. That, however, does not automatically mean the termination of the fetus. It just means, according to these rights, the woman's right to not have the fetus developing inside of her. But that's not what's often discussed, and people believe that it means that the woman has or does not have a right to terminate the fetus. And so when we look at these competing interests and rights, we see that there are, again, the rights of the mother, the rights of the father, of what's known as a viable fetus or a viable baby. And then, interestingly, these competing interests and rights related to the sciences. And so, yes, the sciences are often asserting rights with respect to certain dynamics associated with fetal development. Now we get to a very important question about this dynamic of pregnancy termination. And so currently, in many instances, many women have the right to terminate a pregnancy, to stop a pregnancy. The question, however, is, does pregnancy termination, that right to terminate a pregnancy, does it also include the right of life termination of a viable fetus, meaning theoretically a growing human organism that could theoretically, with support, exist outside of the mother's womb. And so again, does this maternal right of removal also include terminating a viable fetus? And so is the mother given a right to stop the life of the child, distinct from stopping the pregnancy? Hoping that that makes sense. If not, we're going to dig into it a little further and hopefully it'll make sense as we go along. Now consider this question. Does a viable preterm fetus, a fetus that's inside of the mother, but preterm, meaning not fully developed, meaning that the growing human organism has not made it to term, to that 9-month period. Does a viable preterm fetus have a right of intact removal from the uterus? And so while we are discussing the mother's right to stop the pregnancy and have the fetus removed or the embryo removed, we are talking about that usually. That's the debate. But the question is, does the child or the fetus have a right to be removed intact, if at all possible, and the right to live external to the mother? And so again, this goes back to, if the mother has the right to terminate the pregnancy, does she also have the right to terminate the child? And I hope that you see the distinction there. The other question that is generally not addressed, but it ties into this whole dynamic of the rights of the fetus external to the mother. Does abortion include a termination of parental maternal rights over the intact fetus? And so if a fetus is delivered intact or removed intact as a part of an abortion or a stopping of a pregnancy, does the act of abortion also automatically include legally the termination of the maternal parental rights over the removed intact live fetus? This is an important question, by the way. The follow-up to that is, does a father who has been identified, a father who has been proven, or the state, does the father have an automatic custody of an intact, removed fetus? This is not the same as, does a father have a right in terms of whether or not the mother has an abortion or continues the pregnancy or terminates the pregnancy? This is a different question. This is a different dynamic, because what has happened in this narrative is that the growing human organism has been removed intact as a part of abortion. However, the intact, removed fetus that is now a baby, that baby that is born alive or removed alive, now takes on a different identity, clearly. And the question is whether the father has custody of the intact, removed fetus, even though the mother may not have wanted the growing human organism inside of her. Once the entity, the baby, is removed, then paternal rights actually should kick in. And so the question is, what are those rights? How do they kick in? What are the implications for the parental rights of the mother and the parental rights of the father? What's noteworthy about these discussions about abortion is the discussion about property rights. And so there are discussions about the woman's body being her own property versus the property of someone else. There's a question about the extent to which the growing human organism constitutes property, and if so, whose property? Now, what's noteworthy with respect to the removal of an intact, alive fetus is that there could be an argument with this property assertion. There could be an argument that the child now constitutes property. And some people see children in that way, and historically, both women and children were considered property. But when looking at this property interest, there is a constitutional dynamic, and there is an argument for a father at this point asserting a right under the 14th Amendment related to the deprivation of life, liberty, and property without due process of law. And so this is another issue that comes up that has not been clearly addressed. Does the father have this right once the growing human organism is removed from the mother and is intact and alive? One of the reasons why this is important is because a pregnancy is essentially the merging of genetic material of the mother and the father. And when an abortion occurs, there is the discarding of the merged genetic material. Now, what has historically happened is that the mother has had control over what happens to the discarded genetic material. However, the discarded genetic material is not 100% her genetic material. The genetic material, if we're looking at this from a perspective of property law, the genetic material also belongs to the father. And there are questions about whether or not the mother loses sort of this property right to this genetic material, if you will, once an abortion has taken place. And we're going to look at this dynamic of abandonment of property. And so the follow-up question to that is, does the abortion by the mother constitute some form of chattel abandonment consistent with property law? And so with respect to property law, there are certain rules associated with what happens to property when it is separated from the owner. And so once this merged genetic material of the mother and the father is removed from the mother based upon an abortion, is that genetic material then considered abandoned chattel? And here you can see this discussion from Cornell about abandoned property. Abandon refers to the act of abandonment. A party can abandon in multiple fields of law. And abandoning generally, though not always, involves the voluntary giving up of a right. And so this wouldn't be the father abandoning in this situation. This would be the mother abandoning in this situation. And so again, the question is abortion chattel abandonment? And again, many people view abortion as a property issue. And so they see the growing human organism as the property of the mother to do with whatever she wants to do with it. And so when the mother has the abortion and has the merged genetic material removed from her body, is this an act of abandoning this chattel of sorts? Now, I need to make this clear. I don't believe that the mother or the father have a chattel relationship with the child. However, that's the way these discussions have been going related to the rights of the parents. These discussions have a property law feel to them. Okay, and so here it indicates abandoned property is defined as personal property. So we're talking about tangible, movable property left by an owner who intentionally relinquishes all rights to its control. One of the reasons why this is so important is because in the event of an abortion where there is the removal of this merged genetic material, part of the genetic material actually belongs to someone other than the mother. And there are instances wherein the mother is asked to give permission for there to be research on the human fetal tissue. And it's generally the case that the mother is the one who is giving the consent or withholding the consent. However, it's not completely her genetic material. And so the question comes up about whether or not she actually has the right to consent to anything related to genetic material that actually belongs to someone else, particularly when we're talking about it's outside of her body. And here we see this article related to the policies and procedures for the use of human fetal tissue for non-transplantation research. Now, when a mother either gives or withholds permission to use the fetal tissue in research, she is in effect making a decision not only for her genetic material, she is making a decision for the genetic material for another individual, because again, the genetic material is merged. But once the genetic material is outside of the mother, there is little to hold on to in terms of asserting that she has the sole right or the sole power over this genetic material that has been separated from her. And so the genetic material, part of this genetic material, belongs to another individual, namely the father. And so the question becomes whether the mother actually has a legitimate right to make determinations about the use of the father's genetic material in this human fetal tissue research. Is that a right that is reserved to the father once the genetic material is removed from the mother? And as you can see, this can become a major issue. And so there's also the question about the ownership rights of these various entities, since we're using this construct of chattel. So does the mother, when the growing human organism is removed from the mother, based upon an induced abortion, does the mother lose ownership rights from the act of discarding? When the mother discards the merged genetic material, does the father lose or gain ownership rights? And here's a really tricky one. When the mother discards the merged genetic material, does the state gain ownership rights? This is when we get into that Huxleyan question. And while this is not discussed frequently in these general conversations that the public might be having, even right now during this election season, as you can see by the date on this article, this is something that was brought up quite a while ago. It's just not something that we generally discuss because we get bogged down in the basic conversation about whether the mother has the right or whether the mother doesn't have the right to do whatever she wants to do with her body and the body of the growing human organism. But you can see this is an article from 1976. And the title is Fetal Experimentation, Rights of the Father and Questions of Personhood. And so the personhood is talking about the growing human organism. Is it considered a person? What's interesting is a corporation is considered a person, but there are questions about the growing human organism. And so it's fascinating. And so even back in 76, the article was indicating that fetal experimentation is a very thorny problem with respect to the law. And there are questions about whether paternal consent is needed for fetal experimentation. And sometimes fetal experimentation can be inside of the womb and fetal experimentation can occur outside of the womb with respect to a viable or a non-viable fetus. But of course, once the fetus is delivered or removed, if it's viable, then it takes on a different identity. And this article looked at the Planned Parenthood versus Danforth case. And in this case, it was discussed whether the consent of a spouse is needed or was needed in order for a woman to have an abortion. Now, it was, of course, determined that a woman did not need the consent of the father of the child or of her husband in order to terminate a pregnancy. Now, of course, you've probably heard all of the reasons for this, and some of them might make sense to you and some of them might not make sense to you. However, we are talking about a person's body and the extent to which another person should be making health decisions about another person's body. And so you can see how complicated that could become and how complicated that can become. And so one of the other things addressed in this article was this dynamic of asserting that the doctor who performed an abortion had a responsibility to perform it in a particular way. And so it indicates here, no person who performs or induces an abortion shall fail to exercise that degree of professional skill, care, and diligence to preserve the life and health of the fetus, which such person would be required to exercise in order to preserve the life and health of any fetus intended to be born and not aborted. Any physician or person assisting in the abortion who fails, essentially, to take such measures to encourage or to sustain the life of the child, and the death of the child results, shall be deemed guilty of manslaughter. And so basically, what was being stated in this rule was that physicians needed to take the same care with a fetus that was being removed through abortion that they would be taking if it was a fetus being removed because it was being born in a natural manner. And so there was the assertion that the baby had a right to live outside of the mother, or the baby, the fetus, had a right to intact removal in the best way possible. And this was ruled against. And so the court held this provision to be unconstitutional. One of the reasons for this is that the court stated the state cannot regulate or prescribe abortion during the first stage. And so it really didn't address the question of the right or the rights of the fetus in this particular determination. And so it will be interesting again to see this issue present itself again, addressing very specifically the rights of the fetus to be removed intact, and the rights of the fetus to receive appropriate care in order to facilitate healthy removal and also life after removal. The discussion goes on to indicate, while recognizing the importance of the marital relationship and the deep and proper concern and interest that a devoted and protective husband has in his wife's pregnancy and in the growth and development of the fetus she is carrying, the court stated that when the husband and wife disagree, it is an obvious fact that the view of only one can prevail. And that's where we're talking about these competing interests. That's what happens with the law. All of these disputes are about competing interests, competing rights, and whose rights are going to prevail. And it also indicates, and since it is the woman who physically bears the child and who is more directly and immediately affected by the pregnancy, as between the two, the balance weighs in her favor. Now, I've heard a number of individuals talk about this dynamic in a way that is extremely myopic, extremely simplistic, and in some ways relatively narcissistic. And this is whether we are talking about one side of the discussion or the other. But what is really striking is when individuals who don't even know a particular woman, when they want to make decisions about the body of a woman that they don't know. They don't know anything about an individual woman's health. They don't know anything about the circumstances of all of these individual pregnancies. They don't really know anything. But there have been instances where the women have been referred to as selfish and narcissistic. And this is fascinating because, again, generally speaking, these general conversations are not addressing specific women or people that the individuals know. So they are just sort of speaking generally. And in some instances, people might not want to address this, but not all individuals who become pregnant are actual women developmentally. Okay, and so this issue, again, is a lot more nuanced, a lot more complicated than many people would like to admit, because they want to look at it in a very simplistic manner. They have some personal opinions about it, and that's what they want to see happen, whatever it is they personally believe. And then because of boundary issues, some people really believe that they should have the right to determine what goes on with someone else's body. We saw this recently in certain situations, and we see this again with this discussion. And so, again, sometimes a lot of people have lots of boundary issues and they don't know where they end and another person begins. And that's a part of the thing that complicates a lot of these discussions. And so we don't really get to the heart of many matters when discussing the abortion issue. And so, again, it indicates here that it is the woman who physically bears the child and is more directly and immediately affected by the pregnancy. In other words, this is the only person who is living the pregnancy. This is the only person experiencing the pregnancy. No one else is living this. And so no one else, generally speaking, just random people off of the street, these individuals should really have nothing to say about why the woman is doing it, her motivation for doing it, because generally speaking, they don't know. They don't have a vested interest. And many people want rights to determine what other individuals should do, but they don't want any related responsibility. And so when we start talking about exercising rights over the lives of others, we need to also think about, okay, what responsibilities do we have in relation to the exercise of these rights to make these determinations? Because again, with much right comes much responsibility. However, many people want to have much right and no responsibility. And the article just goes on to indicate yet again that there are competing interests, there are competing rights, and the balance has to weigh in favor of the mother. And so that's pretty much a common sense dynamic, but some people don't appear to have that common sense. They really believe that the balance weighs in favor of the general public. The general public that is not necessarily involved in the situation. Now, this again is separate from the merged genetic material and the right of the father to his own genetic material. This is separate from the right of the fetus to intact removal and care distinct from the mother. So now we're talking about something different because we're no longer talking about her health. Because once the fetus has been removed, it's no longer about her and it's all about the fetus. It's all about the intact baby that has been removed. And when that takes place, the question becomes, what now are the rights of the father? And I would argue that the father's rights are elevated in this particular situation. And consistent with the Huxleyan dynamic, what we've had so far are these conversations and these debates about the competing interests of the state versus the woman. Okay, and so we really have not included the father in these discussions in terms of the interests of the father. We don't really discuss the interests of the growing human organism. It's really about the competing interests of the state and the woman. That has been what has been generally on the table. So in addition to the discussions that we have about state's interests and the interests of the mother, it would be really helpful legally and societally if we would increase our discussions about the rights of the father in this entire dynamic. Because again, there are some things that are going on that involve the father that we are not really discussing. And so again, it's related to that genetic material, and it's related to the rights to the baby once the baby has been removed from the mother through the process of pregnancy termination. So if the baby can be removed from the mother and saved, and the baby can flourish outside of the mother, there are questions about, well, what are the father's rights in that situation, and what are the baby's rights in that situation. And so there are a number of questions that need to be addressed with respect to the abortion conversations. We need to have more general conversations about, first of all, why individuals feel the need to have an abortion. Why is that occurring? What's going on with the maternal and paternal relationships? Does the mother feel supported? Does the mother have whatever it is she needs in order to have a healthy 9-month pregnancy? Does she have that emotional support? Does she have the type of relationship that would support a healthy pregnancy? Does she have the anticipation of continued support? What is society doing in order to support the mother and the father and the baby prior to a baby arriving? And so if people have so much interest in making decisions for the mother, so much interest in having rights to do that, again, just like with the father, responsibility comes with that. No, it's not just the mother's responsibility or the father's responsibility when other individuals want to assert a right over such individuals. When we start asserting rights, responsibility comes with the assertion of those rights. And if we don't carefully answer these questions and consider these questions, it's very easy to go down that Huxleyan slope wherein the rights of the mother, confusing, the rights of the father, confusing, the rights of the baby, confusing, and perhaps the state taking on more rights than the state should be taking on, and even science taking on more rights than science should be taking on. So there are a number of questions, again, for us to entertain as we are having these conversations, and the answers are not these one-liner answers that people are giving about, people being selfish and things like that. The issues are a lot more complicated. And we need to own the fact that the issues are a lot more complicated than many people believe. And each situation is a unique situation. So there's no blanket answer to all of this. There's no blanket response to every pregnancy or every desire of a mother to terminate a pregnancy. There's no blanket answer because all of these situations are unique. Every situation is unique, and we don't necessarily have the information to inform all of these questions for all of the people. And so it's just something to keep in mind. Also, when individuals are voting, keep in mind that generally speaking, the candidates that people are thinking about voting for at the federal level, they really don't have the power that many people believe they have with respect to this particular issue. And it's also important to keep in mind that a lot of what's going on is substituted judgment. Remember, knowledge is power.